Okay, we're live.
Okay, thank you so much. Right, good morning to the both of you. My name is Ariane Vuono. I'm an Associate Justice of the Appeals Court, and I'm sitting as a single justice and presiding over this matter. So I understand that you're both can hear and see me. Is that correct? So Mr. SUCHODOLSKI, is that how you pronounce your name?
That's correct, Your Honor. Good morning.
Okay. Good morning. And Attorney DeLinks, is that how you pronounce your name?
Yes, Your Honor. Good morning to you.
Good morning. All right, so there's two cases on for today. Let me officially call the case. It is DEUTSCHE Bank National Trust Company versus Thomas SUCHODOLSKI and others. The numbers are 2023-0211 and 0212. Mr. SUCHODOLSKI, you have about 10 minutes or so to explain to me what it is that you're seeking today and why you believe that you are entitled to the relief that you are seeking. We don't have any rebuttal in the appeals court, so after you tell me what you need to tell me, I'll then listen to the attorney's argument and hear what she has to say to me, and then I'll take the case under advisement and render a decision. Okay?
Okay.
All right, so I have a timer here with me, so I'll give you some warning as to how we're going with respect to your argument. And why don't you go ahead and start?
Okay. Good morning again. Before I begin, I just wanted to request that this court takes notice that I'm not a trained attorney. I appear here pro se, non-U.S. Born citizen, and English is my third language, so excuse for occasional blunders or some additional time I may need to follow the proceedings. I wanted to open up by saying that I filed this morning a supplement to my notice of appeal and a notice of clarification, which clarifies that while the docket nature appears to show that this is for the appeal of the bond under section, under chapter 239, section 5 and 6. In fact, my notice of appeal was filed under chapter 261, section 27, A through G, and I have been for a long time now communicating that matter to the Western Housing Court, who have been, unfortunately,
I received it. I received your motion. I've had a chance to look at it. I can't promise that counsel hasn't had a chance to look at it since it just came in this morning, but we'll address it if we can. Why don't you tell me what it is that you're seeking under with respect to this motion? In other words, my understanding is that you feel that you're entitled to a waiver or a substitution or government payment for the appeal bond and other costs, but there is no appeal bond that's been set in this case, correct? The only thing we're talking about is use and occupancy payments.
That is correct, Your Honor. That's where I exactly was going. That during the December 23rd, 2021 hearing, the court waived the bond. However, did not waive the use and occupancy payments, periodic payments based on my request. And
you think that can be waived under this statute? Is that your point? Under the
yes, my point, Your Honor, is that this could be waived under chapter 261, section 27C4, which states specifically that if the court makes a finding of indigency, it shall not deny any request with respect to normal fees and costs, and shall not deny any request with respect to extra fees and costs.
So are you saying that, let me ask you a question. You're saying extra fees and costs are actually that use and occupancy payments fall into that category?
I believe, Your Honor, and I'm trying to respond as well as I could to your questioning, Your Honor. My understanding
you're doing fine.
My understanding is that based on the recent appeals court decision, Silva v. Stanley, I'm looking for a number here.
Well, is it in your motion?
It is in my motion.
Then I'll find it. Don't worry.
Yeah. In the Silva v. Stanley appeals court specifically undertook the the interpretation of what constitutes the extra fees and costs. The case number, by the way, was 21-P-1132, which was decided on January 9th, 2023.
Okay.
And then the court quotes pursuant to Adjardi 481 Mass at 845 that the appeal bonds are included in 27A definition of extra fees and costs, and there's a complete reasoning that follows, including the footnote that this was footnote number 2, where the court states that although the definition 27D includes appeals bond, which can be ordered in summary process cases pursuant to 23 section 5, the definition does not include periodic payments, which may also be imposed under 239 section 5. And the significance of that omission from 27D is not for us to decide. So the court sort of left this significant issue unresolved. However, based upon the fact that this was a significant issue, combined with a couple of others elements of Ms. Stanley's appeal was allowed to go forward. So I just wanted to reference that.
Well, okay, so I'll read that case more carefully, but as I understand it, you are interpreting extra fees and costs as to include periodic payments for use and occupancy. That's your position? In other words, on what ground are you saying that even an indigent person, on what grounds are you saying that that person is not responsible for use and occupancy? Is it because that amounts to extra fees and costs, or is there some other rationale that you want to provide to me?
Well, so extra fees and costs is definitely one rationale, because that's the that's the and by the way, going back to the decision, the court also cited specific case where the lower court honorable judge basically excluded extra fees and costs, and there was a whole argument why he should not have done that. So anyway,
okay,
since I am a little bit out of my track by now, I think I will refer Your Honor to reading my today's filing, which explains this in much more detail.
Sure, I'll look at it. As I said, I looked at it when it was first filed quickly, but of course I'll look at it in more detail. But let me ask
additionally, Your Honor, and probably more importantly, I wanted to add some specific related to my case. So in the memorandum of law, when the lower court decided on plaintiff's motion for summary judgment, there was a specific legal basis that the court used, which was Chapter 186, Section 3, to determine that the plaintiff is entitled to the award. Now, I believe that this is an incorrect basis that the court used, because that law specifically applies to tenant-landlord case. And as a matter of fact, again, I'm describing this in more specific details in my filings, where I say that that Chapter 186, Section 3 constitutes a tenant-landlord law case, and Section 3 specifically refers to the term that plaintiff used, which was occupant at sufferance, and then the court itself, in the motion in a memorandum of law on the motion of summary judgment, misinterpreted the term sufferance occupant, which that specific law does not even describe. The 186 Section 3 specifically talks about tenant tenant at sufferance. Tenant, to be understand, a person that has a rental relationship with the landlord or the owner or the plaintiff, as they claim to be. And this is not the case in this particular instance. We have never had rental relationship with the plaintiff, and court actually acknowledged that in their ruling, stating that we have never entered into any rental relationship. So the court, I believe, I don't want to use inappropriate words, but it appears to me that the court is sort of misinterpreting or manipulating the terms here, purposely or not, trying to create an impression that this particular chapter of law, of this particular statute, applies to our case. By the way, the court did not specifically cite any legal cases, so it was sort of a very bold statement that this chapter of law applies, period. The plaintiff, in their motion for summary judgment, made the same argument, which I believe court probably followed, and the plaintiff specifically referred to some citations which, upon closer reading, were misrepresented to the court. So, for example, there was a citation of Batty 218 Mass Appeals Court, Lexus 12 at 7, where upon reading, I realized that the fact pattern in that case completely does not apply and is not similar to our case. Over there, the defendant or plaintiff, don't know which one, was claiming that she was a self-proclaimed tenant at sufferance, and the court completely denied that notion. And
Okay, so I understand it.
Entitled to protection under 239, Chapter 239, Section 8A. So my argument here, Your Honor, is, to close it up, is that from the get-go, the court used invalid legal basis to determine damages, which then were used in subsequent motions to set bond and somehow transposed to be under 239, Section 5 and 6. I believe that court's ruling invalidates any subsequent post-judgment court orders because of that mistake.
Okay. All right. So I understand the various errors, alleged errors of law that you believe that the judge made. Let me just go back for a second to this issue of use and occupancy. For example, let's if I were to disagree, and I'm not saying that I do, but if I were to disagree that the use and occupancy payments falls within the category of fees and costs, do you have anything you want to tell me about the amount of use and occupancy that was already established in this case?
Yes.
What would you like to tell me?
Yes, this is yet another argument that I make in my today's filing, and let me flip to the appropriate page so I can refresh my memory. On one end, again, it was based on the citations used by the plaintiff in their original
well, I want to talk about the amount. Do you challenge the actual amount? Because
yeah, so the actual the actual amount, I'll speak from memory. So the actual amount, which was established based on plaintiff's claim that they're entitled to the determination of fair market rental based on
that's the law, fair market value.
Right.
Mm-hmm.
Now,
and so that number was around 800 something, and I believe that you suggested 500 something instead, correct?
When I attended one of the hearings, can't remember which one, I was specifically under oath questioned about what I think the value of the fair rental value of the unit may have been, and I expressed an opinion that I believe at that time, based on what I know about utilities and heating costs and who pays for those, because there is a central heating system.
Right, you
I
estimated
expressed
a
an
little about
opinion
over
that it was somewhere
500,
in the
right?
neighborhood of $500 or $550. Subsequently,
Sir, I have a question. Did you ever pay that amount?
no.
Okay. All right. Do you have anything to add to respect to the amount
Well,
that you think is sufficient today?
I have never paid this amount because first of all, there was a discrepancy in court's order as to when the payment was supposed to start.
I saw that. Yeah, yeah. And then there was a correction thereafter.
This case was still evolving, and the controversy was evolving. I also subsequently found, Your Honor, if I may add, that the HUD definition of the fair market value of the rent actually consists of what is by definition in Federal Register that I cited in my motion for reconsideration of January 5th, 2022. I'm sorry, 21 or maybe 22. It's in my motion. The fair market rental consists of the core rent and utilities, and this is done on purpose because typically housing agencies and tenants who use this data are looking for getting help from the housing agencies that includes the core rent, which is what a particular landlord is asking for, plus utilities because they're not able to afford it. So that's why how this fair rental value is divided into two.
I understand that. I just and you've answered my questions, and I appreciate that. I will tell you that your time is up, so I'm going to refer. I'm going to ask to hear from the attorney for the bank at this point. I will review your filings that you submitted today more carefully, and then I'll take it from there. So
may I ask, Your Honor, very quickly? Yeah. I was under the impression that we had 15 minutes.
Yeah, and I think you've got 15 minutes.
Oh, okay. Well, yeah.
That's what I have. But is there anything else? I don't want to cut you off. I'm not putting
you on the spot. I just thought it was 15 minutes as opposed to 10.
Oh no, but I let you go back past 10. That was, I said about 10. But is there anything else you want?
I appreciate that. I appreciate it.
But is there anything else you want to tell me before we move over them? Because we're at the 15-minute mark.
I guess at this point I will only add that I would want Your Honor to review my filings that I submitted in writing, and just one other thing that we also in our motion for reconsideration argued for the set-off amount, because since the alleged foreclosure took place, the plaintiff engaged in various tactics to scare off our tenants, which are described in details in our filings. And we were not able to rent the apartments. Had we been able to rent the apartments, it would have been probably easier to afford use and occupancy, but that's not the case right now because we are indigent.
And the apartments are empty right now. Is that what I understand?
Well, we are occupying those apartments because after the tenants moved out, the possession of the units transferred to us as the renter, as the landlord. So we do have, as we testified, we have some property in the apartments.
Mm-hmm. And that's the same today as it was when you testified. Is that right?
That's correct.
Okay. All right. Okay. Well, thank you very much for your argument, and also just to reassure you, nothing is waived. Other arguments that are made in your filings that we haven't specifically talked about, they're not waived. I will review them and respond to them. Okay.
And in closing, may I ask for permission to maybe file a clarification if I feel that I misspoke on a particular question that Your Honor asked me?
You're always permitted to file something, whether or not, when we look at it, we always determine whether or not it's acceptable or not. But I will tell you that you've answered my questions so far today, so I'm not concerned about that. All right, so let me turn to Attorney Dillinks, and I'm going to do the same thing for you as I did for Mr. Suchotolski, which is I have my timer initially set for 10 minutes, because usually that's about what we need, and then you can have your additional 5 thereafter if you think it's necessary, okay?
Thank you, Your Honor. I don't think that I'll need a full 15 minutes, but I appreciate your offer. I haven't had the opportunity to review Mr. Suchodolski's new filing since it was filed this morning, as Your Honor noted. I will say that while I've been on the call, I quickly looked at this Silva versus Stanley case. It's actually a Rule 128 decision, an unpublished decision, and so it has no precedential value for you today as you decide this appeal, which is solely based on the appeal bond order and solely pertains to whether use and occupancy should be paid by Mr. and Mrs. Suchodolski. And so I also noted in the decision that as Mr. Suchodolski said, it expressly said that the appeals court, the panel said, we will not address this issue as to whether or not use and occupancy is an extra cost under the indigency court cost law. However, our controlling precedent finds that use and occupancy is not an extra cost under the indigency court cost law, and in fact, under Bank of New York Mellon versus King, it is entirely appropriate for a court to for a housing court to statutorily appropriate for a housing court to require tenants at sufferance following a foreclosure as the Suchodolskis to pay use and occupancy during an appeal, because it's to provide compensation to the plaintiffs for the loss of the property during the appeal. It's about fairness, really. We have been adjudged the proper the owners of the property now. And even though we haven't executed on that, if Mr. and Mrs. Suchodolski want to take an appeal of the judgment, which is certainly their right to do, then they should be required to pay use and occupancy to the plaintiff during that period of time under 239 section 5 and 6. And that is not an extra court cost law, an extra court cost under section Mass Statute 26 section 261 section 27D or C4 that I know of. In any event, so I think the order can be affirmed. In terms of the amount of the use and occupancy, Your Honor noted it's $821 for each unit, $821. That's based on the on HUD's fair market value of the properties, and I think that's as you said, an appropriate way to determine how much money should be paid in use and occupancy during the course of an appeal. And Mr. Suchodolski did testify based on his opinion that $550 would be appropriate for each unit, but the court rejected that. And this court can look at that record, but I don't think there's anything in the record to undermine what the housing court found in terms of what would be proper for use and occupancy. And our position is that $821 per unit is appropriate. With regard to the other arguments that Mr. Suchodolski made, I had a little bit of trouble following, and I apologize, but it sounded to me like his arguments were going to the substantive basis for the judgment for possession, and that's not what's before Your Honor today. We are solely here to talk about the propriety of the bond order and whether the use and occupancy payments are appropriate. So with that, I think I will wrap up unless Your Honor has specific questions for me.
No, I don't. I'll give you the same time if you'd like to. If you feel as if you would like to respond in writing to the filings that were made today, you're not required to do so. But because you have looked at the case and responded here, so again, you're not required to do so, but if you had wanted to, I would give you time to do that.
I appreciate that. I don't think that's necessary. We're trying to move this along. As Your Honor saw, there's been a lot of delay in the housing court on this matter, and just unintended delay, frankly. So we need to move it on. We need to move this matter forward. So I'd like to have Your Honor issue a ruling as in due course, and we can proceed. I don't think we'll be responding to the papers.
Okay. All right,
today.
great. Okay, well, thank you both very much. Thank you for your time this morning. I have the papers, I have your arguments. I'll look over everything carefully and I will issue a ruling as soon as I can. All right? So